guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, I actually just got back a little bit ago from the dentist. Probably my least favorite medical appointment place to be, medical doctor, however you want to go for it. I had to get a crown, but I don't know what's worse, having to deal with the pain is now coming through, the bit of pain after this Novocaine is wearing off, or dealing with Sarah Boone all the time. But hey, I don't know. I guess it's a toss up, but probably Sarah Boone is worse because at least the pain from a dental procedure does wear off. But Sarah, well, she just never goes away. So she wrote a letter, a correspondence. They have it listed on the Orange County Clerk website docket. And of course, this is about her criminal case. And she is not happy, but when is Sarah like ever happy? I don't think pretty much ever. So again, like I stated, she wrote a letter. They call it on the clerk's website, they call it a correspondence. It was filed yesterday, but most of these things tend to be filed later in the day, I've noticed. I didn't see it till earlier today. But anyway, this is basically her writing to the District Court of Appeals because, well, she's not happy with the way her appeal is being handled, but, she seems to think everything needs to go her way, though, so, nothing surprises me. And look at how long it took for it to reach the, Orange County. Well, I don't even know, it actually went to, Lakeland, but Ocala to Lakeland is nothing, even with the slow postal service. But again, July 22nd to actually getting, filed today, August 3rd. Well, yesterday, August 3rd. Today's the 4th. So let's see what Sarah is complaining about to the District Court of Appeals here in Florida. Sarah Boone versus State of Florida. She lists her case 602025-0206. Dear Sir, Madam of the 6th DCA. In my good faith efforts to abide in accordance with the order given by the DCA to not contact the courts directly and advising me to utilize my court appointed attorney instead in my own advocacy, I must ignore these instructions as I do not know whom else I am to turn to in this matter. Well, Sarah, well, this first paragraph tells us a lot, doesn't it? Because she was told, and she even, tells us right here, she was told to not contact the court, to reach out to her court appointed attorney, which is Maldonado. And there is a copy at the end of her little correspondence here, which we'll get to as well. But Sarah just she's in her own little bubble and she has to follow what she feels is the way things should go. So she doesn't want to follow the rules. I mean, look at what she did. She told the prison, "Oh, well, Santiago told me that I could bring the laptop to my family court hearing." Never happened. So everything to Sarah is, if I think it should be this way, then I'm going to do it this way. So she's always going to get in trouble with this way of thinking. And I mean, we're in August 2026, and she killed George in February 2020. I mean, she's just never going to change. Enclosed with this letter, I have included a copy of the first written communication I received from my court appointed attorney, David Maldonado, where he clearly states he has or had no intention of simply even reading the state's answer to my brief, much less respond to in my rightful opportunities to do so. His exclusive decision to relinquish his legal responsibilities limits my rights to move forward properly in my defense. Above all, Mr. Maldonado's defeating decision was made well before the state's answer was ever written. Well, Sarah, you really have nothing but you can go on for this appeal. But let's continue to read her little complaint. This is deeply concerning as a reply brief can only be meaningfully evaluated after proper review of the state's arguments, yet my counsel predetermined no response would be filed, regardless of what their response would be. His unconcerned approach heavily impedes and prejudices my appeal by restricting any new arguments, proving factual inaccuracies, legal mistakes, and my rights altogether. You don't have any rights, Sarah, but okay. It is my understanding there are significant issues that needed to be raised and properly argued in my case, which cannot be from Mr. Maldonado prematurely surrendering his duties as my defense counsel. Well, that's the problem right there. It is in my understanding. Your understanding and what is actually true and factual, they are totally opposite. Totally opposite, Sarah. This approach also raises legitimate questions as to the level of professional diligence, effort, and careful consideration devoted to the successful preparation of my initial brief as a whole. If counsel had already decided before seeing the opposing party's position that no additional advocacy was necessary. I have done everything I know how and have the resources for to consistently attempt to work with, rely on, be included by my appellate attorney as the court would expect. Due to Mr. Maldonado making clear his position in the written refusal to act any further on my behalf has forced me in my responsibility, right, and as a party also in the justice system, being the appellate, to make the court aware of my critical situation. In all respect due, I ask for understanding in my direct contact and graciously seek guidance from the 6th DCA in this matter. Sincerely, Sarah Boone. She thinks they're going to give her another attorney. We should all just pause here and silently laugh at Sarah because the state of Florida hasn't spent enough on you, Sarah, right? We haven't spent enough on you with all the attorneys all this time to get your case finally heard. And now you're going to complain. I mean, you already had one appeal attorney decide that, crap, this is not even the work for me. He decided to leave being an appeal attorney altogether and move on to some other career. So, I mean, poor Mr. Maldonado, I mean, he's probably just being honest with you. But all right. And she says copies mailed to, and there's David Maldonado, Orange County Clerk of Court. Looks like Kaylee, Assistant Attorney General, Office of the Attorney General, Daytona Beach, Florida. All right, let's take a look at this letter that she's so upset about. So this is from May 21st, 2026. Boone versus State of Florida Appeal. All right. Mrs. Boone, I have reviewed your letter dated May 13, 2026, wherein you state that you did not receive a copy of the brief I filed on your behalf. I am not sure why you did not receive the copy, as I definitely mailed a copy to you as soon as I filed it, so I am enclosing another copy herein in the hopes that you actually receive this one. With respect to the phone call, and as I have made you aware during our last call, I ordinarily do not call inmate appeal clients on court appointed cases, as I prefer written communications. I simply do not have the time or resources on this case to schedule yet another call to discuss the brief, as the brief is self explanatory, and I have made the best arguments I could on this case in light of all the circumstances. As far as what to expect next on the appeal, the state will have an opportunity to file an answer brief, and the matter will then go before the appellate court for review based on the brief submitted. I will not be filing any reply brief and also will not be scheduling any oral argument as I do not believe it is necessary in this matter. The oral arguments are generally not granted on these matters, anyways, from the appellate courts. With respect to your wish for me to keep Nicole Ray Feibiger informed as to what transpires with your case, enclosed herein is an attorney client privilege waiver for your completion. Please review the waiver, sign it, and mail it back to me at your earliest convenience. Once I receive it, I will be happy to provide her with the brief as well, and I can correspond with her to keep her apprised of any case updates. Sincerely, David Maldonado, attorney and counselor at law. And that is the gist of the filing. The bottom line is Sarah, she thinks that she's an exception and that she's an exceptional person, and everything has to revolve around Sarah Boone. Everything revolves around Sarah Boone. But as all these attorneys have tried to tell her throughout the years, and probably many other people that have had to deal with Sarah, that's just not how things work. And this letter obviously tells us right out. He's telling her, this is how things work. And yeah, I'm not going to call you again nor take your calls. And I applaud him for that. I do. Because he's busy. He tells her, I'm busy. I'm a court appointed appellate attorney. I don't have time to talk to you. And we all know Sarah just wants to go on and go, "Me, me, 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 me. My case is so good. I should have been, found innocent. And, you know, like my boyfriend, he battered me. And, I had to put him in the suitcase because I was really scared. And, meh, 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 meh." That's all she wants to do. And we all know she is a liar. And she will just say anything to, keep people, on her side. I mean, that's why she's got her flying monkeys that still hang around her. And, and look at, she wants copies to go to Nicole. So, like I said, Nicole is still hanging on there, in there. I have no idea why. But, if I was her, I'd skadoodle. But, to each their own. But Sarah, you're not going to get an appeal. Okay? It's just not going to happen. The trial was fair, and irregardless of the fact that you decided after the fact that you did not like James Owens, who responded to your ad when you begged for an attorney after state of Florida gave you like 9 attorneys. uh, Judge Kranick, he covered that very, very well. He asked you on so many occasions, I think it was daily, I mean, or pretty much daily, "Are you happy with your representation, Sarah Boone?" "Oh, yes, I'm so happy. I love Mr. Owens. He's the greatest." And that's only until you were found guilty and he just dropped your ass. It was gone. Yeah, he was there, and then all of a sudden when you didn't get your way, now you don't like the guy. And hey, he did this all for free. I mean, the fact that he thought that you were going to ever pay him anything, I mean, I don't know how he would have, even thought that would happen. Because you remember how he went on and said, "Oh, we're going to work something out." And then later on, he said, that he was doing this pro bono. But either way, he responded to her ad and he came down to Orlando to be her attorney. And, you know, it had to have been very, very difficult. And as much as, I tend to not like defense attorneys in a lot of these cases, I think he did the job that Sarah wanted him to do. Let's put it that way. I think that Sarah somehow, I don't know if she convinced him or what have you, the whole battered spouse, defense, you know, that came out and it failed terribly because the jury saw right through the garbage. And the state, as soon as they dropped that, the state was like, hey, for their rebuttal closing, the state's like, mic drop. They showed all of these videos that Sarah took of George when she was the bully. And you can't forget that photo of her with the black eye, right? The black eye that really it has to be that she just drew it on there. She used some sort of a marker, shoe polish. I don't even know. I guess we're lucky that we didn't have chat P back then. She probably would have used AI. But anything to make her look like the victim. That's what Sarah wanted to do. But the jury, they clearly didn't buy it. And that those videos that she took while George was in that suitcase and telling him to shut the F up, that just I mean, there was just so many things that just sealed the deal, but those videos, I mean, even before the interview interrogation with the detectives, that just sealed the deal right off the bat. So, she should have taken the plea deals that she was offered. She was offered 2 or 3. She was offered the last one right before the, trial began, and, you know, she's, eventually, maybe will feel like an idiot for it, but she still thinks she stands a chance of getting an appeal. And Maldonado is trying to tell her, um, I've already done like what I can, and there's really nothing there. But Sarah she just can't, she can't believe it. And she's not going to believe it, I guess, until the appellate court, the appeals court will just tell her, you don't have enough to get a retrial and appeal denied. But I don't even think then she's gonna give up. I think she'll try, 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 try again. I don't think that any of this is the last time that we hear from Sarah. Someone's gonna have to cut her off, and I don't know if she's going to continue to write the Orange County Clerk of Court. She's going to continue to write the DCA, District Court of Appeals. She'll continue to write probably Judge Korenik. Anyone who she thinks might listen to her, she will probably continue to write them until she cannot put pen to paper. But let me know what you guys think. And with that said, I hope you have a great rest of the day. And most of all, stay safe.